Hey, everybody. It's the Impact Litigation team. It's great to be back. Hopefully, Aaron will join us in a second and make us all better looking. Except for Jesse, because he's that as well. I mean, um, I want to start today by talking about the decision we haven't gotten, Jesse, in the lottery case. It's now April 11th. And I did say April. I think you said April too. We'll probably get a decision. But
Chuck, what does ChatGPT say about when we're getting the decision?
You know, have you asked ChatGPT yet? You should ask, Jeff. But what did you tell me? The ChatGPT is not Nostradamus or something like that?
It's the magic 8-ball of the internet.
Oh, the magic 8-ball. That's just looking at. You will have a great day. There we go. If anybody doesn't know what magic
I saw the most interesting use case today for it was somebody has it creating fortune cookie fortunes.
That's awesome.
That's perfect.
That's exactly what that stuff should do. Are they going to pick lottery numbers on the other side too? Because that's,
it's probably accurate.
It's as good as anything else, right? So Jess, we're not going to. We'll get a decision when we get a decision. People will ask questions today. We'll say we don't know.
Yeah, it's coming.
I was thinking about this, Jess. You have frequently pointed out that one judge is clearly ruling against us. No doubt about it.
Yeah.
One judge is clearly ruling for us. So if there was if there was a 2-1 split, they knew we would have the decision. To me, this suggests that middle judge we don't know where he's going yet, or
yeah.
That's the issue here. What do you think?
Yeah, and this may be too speculative, but I'll do it anyway because this is somewhat for entertainment purposes. But there could be a split decision. We have multiple years and multiple cases involved where people are seeking different results. For DV 2020, where I'm counsel, we're simply asking for the class-wide relief that was reserved in that year to be granted. Maybe 2021. I don't know how you would draw a line between the years, but there's also some other companion cases where people are asking for a reversal. And I know in your Go case, you made a compelling argument for why there should be even more visas issued and reserved. So there's a lot to get through. I mean, everyone else is hurting and because they're thinking through the lens of, I need this to happen for me. And I can understand that. And I get messages every day about that. What the court is going to do, though, is change the arc of the law here. And they're taking it serious. And there's a lot of issues that they need to get through because I just was commenting, I think maybe on something Greg had written, there are still policies being out there right now where the State Department is interpreting a suspension on entry to preclude a visa. Nothing to do with DV. Do you talk about Chinese nationals, Chinese nationals? But there's also I was actually doing this the other day. I mean, there are so many 212F proclamations in existence, and so there's going to be a lot more depending on who is the next president. Well, maybe even if Biden wins again. So I think everyone needs to understand while it's personal to the DV, the judges are probably thinking a bit broader than that. And they're also smart enough to understand that the losing party is probably going to go up to the Supreme Court. And they want to write the best decision they can so that they're not reversed.
Because all of these judges believe they should be on the Supreme Court.
And they probably should. I mean, that's
the AAA team for the majors.
Katsas, for a brief period, was the U.S. Attorney General. So I have filed briefs with Katsas' name on it. So he's no slouch.
No,
and he wasn't at the argument. So it's just, as much as we pain for those who are like, hey, I should have been admitted 1.5 years, 2 years ago. Yeah, no kidding. But it's a little bit more complicated.
Yeah. All right. So there's that. I also I didn't put our banner up, so sorry, I didn't put the banner up. I do want to just talk about the EB-5 litigation just briefly. We have oral argument on Monday at 12:30 Eastern Time, 9:30 Pacific Time. We will send out an email to all of our clients so that they can log in and listen to it, because you don't get to watch the oral argument, but you get to listen to it. It's a Zoom-based oral argument. I think we have a compelling case for discovery, thanks in part to the other Jane case in the same district, which the judge ruled against Jane and for the government, and specifically pointed out that, hey, you didn't ask for Rule 56D discovery. You could have gotten discovery.
Yeah.
So we'll see if the district talks about both sides of his mouth. I'm excited about this. I think this is going to be a fun oral argument. I think government counsels, I think she's a very good lawyer. I'm looking forward to hearing her discussion here. But tune in.
You know, I have to send you all. So in the DaCosta case that I'm about to argue in the DC Circuit next month, I filed a reply brief yesterday because, you know, we got an amicus that had I think some evidence that you saw as well, where there's no question they had gone contrary to their purported visa availability approach. And my reply brief was actually, why wasn't this information disclosed to the district court judge? Because it was in the hands of and how can this possibly, like this hide the ball approach for the appellate court? In my case, I'm like, we now know that what the factual allegations were correct, that they were skipped, they were bypassed by about 500 people. Which in the EB5 world is significant.
It's a big number. It's a big number.
Since, you know, you may do like 1,000. And I just wrote the whole reply brief, like, because when they were presented, they didn't even address the amicus. They put it in a footnote and said, we don't even know. I'm like, no, these are your receipt numbers. Actually, you do know. You
know.
Yeah. I have a hard, I'll tell you, I've said this before. I don't really. I think we have a very difficult case to argue for in reasonable delay in the EB5 world. I do. I think courts don't want to get involved. However, if we win, it's going to be because they have not. They file things in district court that they know are not true.
Jess, would you? I don't know if you share with me your reply brief. I would love to read that.
It's. I never like to be critical, really. Too critical. It's about a bit as critical as I actually think that, because I've been on the other side of that, where judges have accused DOJ when I was there of, hey, if you don't tell us all the evidence, like, how are you standing before us telling us when you know things are not true? Isn't that a problem for you personally, sir? I'm like, I think it is.
My client didn't tell me, Your Honor. Sorry. My client lied to me. Well,
but I do think in delay litigation, it goes a little bit bigger than that. I'm starting to get really interested and involved, because they file these motions to dismiss. The whole point of it is to tell the district court judge that we're following a rule. And that's fine. If it's true. If it's not true and you're saying it,
that's a
problem. That's a problem. That's a problem. And at the time they file the motion to dismiss, probably in Jane and some other of these cases as well, they know they have to disclose that they're skipping people. As far as I'm concerned, they have to. That's not even negotiable. Like, you have to do it. And we're starting to uncover a lot of, like, maybe in the 601A, and we can transition that. If you know you're not going in order and you tell the court you are, it's a little bit more than discovery at this point. So I'm going like discovery plus here. We need to have a conversation.
Well, you know, it's interesting because the government took the same tack, because we submitted that evidence. So we got the amicus brief. We got the underlying information. We included it in our motion for Rule 5060 relief. The government ignored it.
Right.
Ignored it. It's like didn't even exist. It's just what? I don't see anything. Do you see it? I don't see anything.
I got to be honest with you. I would be like, if it goes the way it should go, if I'm the government, if it goes the way it should go, I should win, because it's a delay case, and infinite delays are fine in our view, right? If it goes bad, I'm dead. I'm dead, because the court's going to say, you withheld this information. How can you do that? Please explain how you can do that.
Jesse,
And I think the right federal judge will be really concerned with you're saying one thing, and you know it's not true.
Jess, what day is your oral argument?
May 11th.
May 11th. We'll have a decision in the Jane case by then.
Yeah.
I'm going to 60 motion. You might be filing a supplemental brief with some new authority from a district court, at least on this. We might lose. I mean, it's up to the judge, right? But I think we have a compelling case to sit down and depose the head of the immigrant investor office and say, what's going on?
By the way, just to change the subject a bit, I was going to tell you something funny. Urge Ado was on a Migration Policy Institute live stream this morning.
Yeah, did you miss one?
What's that?
Did you listen to that?
Yeah, so I was watching some of that, and she was at the beginning kind of ticking off the accomplishments of the agency, and they have some things that have been pretty good, some policies that have come out on a couple issues, and she talked about them. But one of their accomplishments that she listed was automatic work authorization for E2 spouses. And it was like, you mean the case that Jesse had to sue in order to get you to do the right thing on that? It's like, that's your accomplishment, is that you lost a lawsuit?
Yeah, I know.
Well played,
I do think USCIS leadership wants to do a number of things, but the thought of call us before suing us just hasn't worked. Like we've tried it.
I disagree. I think they want to maintain the status quo, make it as hard as possible to immigrate to America, because their actions suggest that.
Right. And then when they lose, when they lose or they change a policy because they know they're about to lose on there, then they all of a sudden they're magnanimous and it's policy and they're trying to do great things and all that, but it still took a lawsuit to get them to do it.
Yeah.
Jesse, you give them far more credit than I do. I still think this is the worst run government agency.
I know. I'm trying not to give in. There's so much bad news out there. I know. I'm looking to keep the light on there.
Let's talk about the 601 delay case, 601A. We're preparing our response to the government motion to dismiss. It's not as bad a motion to dismiss as the Kaczmarek abortion decision. But it's a pretty bad motion to dismiss. I mean, I've read way better motions to dismiss in my career than this. But the best thing really is the delay and the hardship is caused by these people's choices, not by us taking 4 years for the forgiveness that's written into the law.
All right, they had it coming.
It's their fault. It's their fault. That's the best part.
That's the essence of their argument, is they had it coming.
No argument.
I do think the public should know that they're arguing essentially that the decision to decide is up to them and can't be reviewed.
Right.
Like that. Yeah. We can decide.
It doesn't matter.
We cannot decide. You can pay us. You can pay us. You can pay us and we can just sit. We can never decide. We don't even need a rule.
It's a fundraiser.
Yeah. We can just raise funds. They should do that. Like, so if they said, hey, listen, file all of your 601As and we're going to have like a fundraiser. Yeah, we're going to give you half off. You do it. And then they would say, oh, you can't sue us for a decision because actually we don't need to decide these ever, which is their position. Yeah. And it's important that Judge Lynn is going to make a ruling, and it's important that we win because, boy, is that extremely that would be a catastrophic decision if they said the agency can take the fees, and never issue a decision, and there's nothing you can do about it.
I don't know who's going to argue this case. Honestly, I would love to argue that. I would love to say, Judge, I just want to restate so I understand clearly the government's position, because they'll go first. They get to argue first, right? It's their motion.
Yeah.
The government's position is, Your Honor, they can take the money of our clients and similarly situated individuals around the United States and never make a decision, and you can never make it.
Chuck, you could take this argument to some, funny extremes. Like you could say, the government's going to say, we're going to have a lottery and we are going to adjudicate half the cases and you have to pay us. And maybe you'll be in the half that gets decided, and maybe you won't. But you have no recourse under their argument. If they said they said, we're going to, we're going to take all this money and you have a 50-50 shot of us even making a decision on it. They, under their argument, that would be perfectly fine. And what's do that kind of thing, or say we're gonna adjudicate 1 out of 10, the other 90% we're gonna pocket, and you have no recourse.
But we will transfer your file to a different place where we also will not adjudicate it.
And what's really extreme about this is they're trying to use the Supreme Court's decision in Patel, which was a removal case where they said, listen, certain determinations in removal proceedings for adjustment of status applicants cannot be reviewed. And I know courts have stretched that to adjustment of status denials in non-removal cases, but this would be different because this person, the whole premise of a 601A waiver is you don't even get to apply for adjustment of status. Your whole point, you have to get it so you can leave in consular process. Like, how can you make that argument when these people will have no recourse? They have nothing. So you're taking every opportunity away from someone. Now, keep in mind, these are people with approved immigrant visa petitions.
They're married to citizens for the most part. They're married to citizens, right?
And they're paying, they're paying an enormous amount of money. They're not allowed to work. And now you're telling us that the Administrative Procedure Act provides no recourse, even though it plainly states that agencies have to operate within a reasonable amount of time. Okay, let's start there. Like, what are we talking about? Is this?
I do want to emphasize one thing. This is the Biden administration arguing this.
Yeah.
It's not the Trump administration.
Yeah.
A Biden administration can say, you know what we're going to do? We're going to take the APA and we're going to make sure that if Trump comes back, that there is weapons available to fight craziness.
I've told you before, the executive branch is there's no difference. They all want power, right? It's like Abraham Lincoln's not walking through that door. Okay. I feel like Rick Pitino. I'm like Rick Pitino talking about Larry Bird, but I mean, literally, like, it's the executive branch. Their whole, like, if you get the card to be president, your whole job is to basically gather as much power as you can for him or herself.
Well, and that's what I want our plaintiffs to know is we are fighting against a force that is not good. This is not a good thing to have an executive branch with ultimate power, because we saw previously it can be massively misused. We're seeing that now.
Well,
for the privilege of getting us the ability to argue this.
I hate to turn this into a history class, but I am close to Lexington and Concord here. And, we did fight a war over that a couple hundred years ago. I mean, like, this is ridiculous how because they're telling you that Congress, they know Congress doesn't do anything, right? No. So they're saying that Article 3 courts, who are supposed to have equal authority, have no authority.
Well, and the whole check and balance thing, isn't it?
I know, and I keep making this argument. I keep making this argument, but some way or another, Justice Gorsuch is going to gather a majority and absolutely swing the hammer back on Article 1. Like, it's over. It's coming. It may not be an immigration case, but it may be. I don't know. But their government, the DOJ, is going to press their hand too hard with this executive authority, and there's no review ever of anything, and it's gonna come back to bite them. I know it.
All right, we're going to jump over to 601 litigation. I just read the draft complaint this morning. I think we should have that ready to go in the next couple of days. We've got 14 plaintiffs we're filing for. We're going to keep taking cases and keep filing. It appears we're making final decisions, but we may be in Nebraska to avoid issues of venue changes from the government, because all the cases are in Nebraska right now. We're just, it's not the greatest court as far as this kind of thing. There's a lot of bad stuff there. But we got plaintiffs in Georgia. We could do Georgia, but it's the 11th Circuit, Patel. Home to Patel, actually. So the birthplace of Patel. I wanted also the prevailing wage. We told everyone we will sue the Department of Labor. Everybody wants to complain about them taking a year and change on prevailing wages, but nobody wants to force them to do it sooner.
Well, I'll tell you, I've heard this more and more. We kind of had a momentum, but if you've looked at a lot of the litigation, the antitrust, and some of these against social media and tech companies by the Biden administration, I think it's really started to freeze out and create a sense of fear, like even in crypto world and banking and all that. Like this whole like government's coming for you attitude definitely is impacting businesses who would probably, would have sued before. I don't know. That's my understanding, but I've had a lot more
companies. I mean,
I've had a lot more employers and even immigration firms tell like, hey, the risk of retaliation is too great for us to sit here. So I'm like, okay. Well, and I tell people this all the time. I'm like, listen, that's great. I sue when I'm told. If you want to wait, I'll talk to you in 3 months. I mean, like I honestly like good for you.
One of the problems is that the employer has to be the plaintiff, and the person who's really bearing the pain is the employee.
Right.
Yeah.
So, in a lot of cases, the employer sort of like feels like they're just doing a favor for the employee when they're trying to sue in a case like this. Yeah. And that's something I think that if they felt it was sort of like their problem much more directly, they might be more willing.
Yeah.
All right. Next thing I want to briefly mention, the H-1B lottery FOIA case. I just realized I forgot to serve the U.S. attorney.
Being rectified.
So it's being served today. Government will have 30 days. They'll get back to me, and we'll get the answers. But it's stunning. Greg, did you see the numbers that were released? No, they didn't release them.
We only know what everybody knows.
There's no. Now I was looking at last year. By this time last year, we knew how many applications came in.
Right, we don't know that.
How many people were notified? Okay, they weren't. They've never ever told us, even till today, how many master's applicants there were and how many bachelor's applicants. They've never said it. That's one of the FOIA questions. But this year, again, the calculation suggests, as Greg has noted, probably about the same number of master applicants as previous years, but far, far more bachelor's applicants. Far more.
Yeah.
And I just learned yesterday from an employee who didn't get picked for the 4th year in a row, from a major, massive U.S. employer, that their overall selection rate was 15%. A big employer. Most of their applicants were master's degree holders.
Yeah. And
they were 15%, which suggests that there's got to be at least 700,000 applicants.
Okay. Well, what we're going to find is that about 85% of the people selected are going to be working for IT staffing companies.
Yeah, that's the only, at least. I did have one.
That will be very interesting because that's going to have that's harder for them to hide because all that information on, is
they release the employer.
They'll start have to putting that. I don't know, Chuck, in your FOIA, if you're able.
I didn't go into that level of detail.
Yeah, but that's what I feel like we're going to. The evidence is going to show that if we can get that information from USCIS.
I wonder, can I ask a question that may embarrass myself, but I think I have a theory. So that if this is true and this is what the H-1B program has become, because what I've noticed is just dealing with a lot of consular issues and suing is that the State Department, for these people who are in these staffing company employer-employee relationships, let's go for it for a while, they're getting a super hard look abroad and getting revoked, and it's getting sent back, or so the whole H-1B program is actually being harmed because the Department of State is not playing the same game that USCIS is, and the employees are the ones being suffered, because I have so many people contact me about what they can possibly do because they're in administrative processing. And I'm like, you could sue, but how good is your underlying petition? And then we look at it, and ultimately we wait, and it gets sent back for revocation because the state.
One other interesting part of this is that there's a real shift to consular processing here, because most of the selectees are not in the United States, people that are winning the lottery. In past years, it's been a lot of people that are coming off of OPT, students transitioning to H-1Bs. and they're already in the United States. So it's USCIS is the one that is burdened with the next application as a result of winning the lottery. Now USCIS has essentially shifted the whole thing through neglect, shifted a big chunk of their workload to the consulates because that's where all these winners are. Which I suspect that's probably not the reason why they're doing it, but it is an interesting problem, and it's going to create problems for the consulates as well, as far as workloads go.
So there you go. Let's look at some of the questions here. We'll be done here shortly. We've got let's see. Hi guys. We got any update on FOIA? We talked about that. H-1B didn't work out 4 times in a row. That's just awful. Can I change my F1 visa to visit after my AID expires on July 6th? Well, the problem is changes of status are taking a year.
I wonder if that would be an interest. If you had an employer that's already filed an I-140 for you, let's say if you're on STEM OPT, whether that would be a good use of a compelling circumstance EAD application.
Let me know when that unicorn's head pops up.
Well, I mean, it does seem like they're trying to utilize that now in the layoff situations. But it wouldn't surprise me if that's something that USCIS could potentially be a little bit more lax on.
We'll see. I guess we'll see. We've got Kiara. Someone in the going to get an update. Is on review? That's a good question. These things that they write on there, some of them don't make sense to me, because if you never sent anything, what does that mean?
I noticed that I just actually we haven't had any new transfers or anything since last week, but we have had two cases where in the last couple of days or actually we've had several cases where it said correspondence was received and USCIS is reviewing it, Chuck. And that's at least since March 14th, we have at least 6 of those.
Received by who? Under review by
it doesn't tell you anything. That's the problem with the data scraping is, sort of like we see what you see. We only see what they posted, and correspondence received and under review might be an expedite request or some kind of something like that, which may be pretty meaningless.
Change of address. I mean, who knows?
Right.
Vince, any news H-1B? There you go. It is a scam. It's a scam. I blogged on it, I believe. I was so angry when I wrote that blog, and I went back and read it. It's an angry blog. I decided to be here with Greg. What kind of razor machine will you use in the future? I think he's.
I've been using one that's got these guardrail or whatever on it. It's supposed to make it stay the same length. I don't know.
It looks good. By the way, I think Greg now looks like Mandy Patinkin.
It's not Potemkin. It's Patinkin.
Mandy Patinkin.
Potemkin. That was like
a lot like it.
That's a Russian a Russian novel term.
Oh, that's right. It's also a warship from the Korean War, I believe. Yeah, Potemkin. What is the probability we have finance for by the end of the year?
End of the year. Well, I guess we're hoping if we haven't had some.
It depends on whether we get discovery. If we get discovery, no. But if we get discovery, they're going to be adjudicating cases fast. So
I got to run.
All right. See you later.
Bye, Jess.
Yes, we will. We'll be. Aaron will be in touch. Carly, he'll be in touch shortly. Response of bad choices. Yeah. That actually is. That is a really interesting approach, Greg, for oral argument. The government is essentially arguing that the U.S. citizen made a bad choice in who they married. That's what the government's arguing. The government shouldn't be arguing that.
That kind of reminds me of, Chuck, one of the worst argument, and we threatened to go to the media with it. We had a J1 waiver that was an exceptional. It was a hardship waiver based on the couple wanted to. That they had a child, and there was a hardship. There was a civil war going on back in the country. Anyway, they argued that they should have thought about that before they got pregnant with the child. That they should have been, and they even suggested, I think, in there that they considered that they could have engaged in family planning techniques. That was one of the most shocking decisions I'd ever seen, and we immediately wrote them back and said that we're going to the media with this, in which case we had it approved immediately at that point. But that's kind of like what that's sort of what they're saying, is that they had it coming.
Jordan asked a question. He's in H4 status, curious if he gets a DED EAD card. Well, you would no longer be in H4 status if you're using a DED EAD card. But you definitely want to talk to a lawyer and get actual legal advice, not the opinion of these two locos on Twitter or wherever you're watching us. Yeah, I agree. I think that's a very interesting. I don't know if I'm arguing or Jesse's arguing on the oral argument, but see, Jesse's a really good oral. Jesse's argued countless times in federal court, and he has a really good way of doing it. He's very focused and very. I get a little animated, as Greg learned in our lottery case. So we might both argue. That's what we did in the lottery case. We each argued. So kind of give a good cop, bad cop kind of thing. Will we get notification when season 1 is filed? Yes, you will know before it's being filed. And that's why we'll probably file in Nebraska. Probably because it's easier for jurisdictional purposes. But we haven't decided yet. We're going through all the case law, all the places we can file. We have different options.
It used to not be that much of a.
It used to make a difference, but now it does.
Yeah, I mean, where we filed, the government. I mean, that was the government would argue a lot of times to change the venue, but it was one that rarely worked on their part, and they've had some success on that in the last couple of years. So now we're thinking more seriously about where we're filing. My
wife was mentioned in the government object to classification motion that she filed. This is wrong. She filed. What's wrong with this? Oh. Thank you, Kaneet. I will make sure that we're aware of that going forward. She's second round plaintiff. Gustavo, probably we find the answer. 601 last. Again, I think you asked this question earlier. And finally, not finally, Jorge, does AVR apply for F1 while in STEM, OPT, and expired visa? Greg, AVR? Automatic visa revalidation. Mm-hmm. We don't know yet because they haven't.
Well, my understanding is that it's going to only be for H's and L's.
I don't think
at the beginning, and then they'll start extending it to other programs probably.
I think the reason why initially, Greg, because Fs require a foreign residence requirement intent issue, whereas H's and L's don't have that. So it's easier for them to automatically revalidate an H and an L.
Probably.
My name is transferred early January before I joined. It was Nebraska. Filed a normal processing of the papers done. I submitted a request. So Evo. Did you get an email? Does your online status say that we received your correspondence? I don't know. Vince, please read my previous comment complete.
Oh, let's hold on. Let me go back to that. Any news on H-1B? Is FOIA just another scam to divert attention from the abuse?
Oh, no. I mean, FOIA is how we get information. FOIA is not a scam. FOIA is actually super useful. So yeah. It's just that they just ignore it. A
lot of times FOIA is what we need to do in order to figure out if we can sue on an issue. It depends on what we learn in the FOIA. Yeah.
But the thing is, federal law says when you do a Freedom of Information Act request, they have 20 days to respond. And if they don't respond in 20 days, you can sue. Mm-hmm. And they never respond in 20 days. And their argument is, we're too busy. And the courts have said, okay, they're really busy. But this FOIA request requires no effort by them. Literally, it is all information that they have to have. Mm-hmm. They just refuse to release it. And it's not secret information.
Yeah.
All right, Greg. Great seeing you this week. I'll be live tomorrow. I missed my session last week because I was actually engaged in a court case, so I couldn't work on it. But I'll be back tomorrow. Greg, are you doing live still or not yet? Or
nah, I'm too busy writing.
Man, I love doing lives. There's so much fun answering people's questions. Just great. So we'll see you next week. Thank you, everybody, for staying tuned. We'll see you next Tuesday. Bye-bye.